Supplementary list. Item number 1 for judgment. WDC 14616 of 2021.
Read courts should be slow in disturbing the regular procedure and seizing statutory powers from the competent authorities. However, it is clarified that this court is not incapacitated to interfere when it is pleaded, supported by clear and undisputed prima facie facts that the very issuance of so-cause is per se arbitrary and is of mala fide character and has been issued by an authority which is not empowered to do the same under the law. In a very rare and exceptional case, the High Court can quash a so-cause notice if it is found to be wholly without jurisdiction. A so-cause notice does not give rise to any cause of action as it does not amount to an adverse order which affects the rights of any party. It is quite possible that after considering the reply to the so-cause notice, the authority concerned may drop the proceeding and oblique or hold that the allegations are not established. A so-cause notice does not infringe the rights of anyone. It is only when a final order imposing some punishment or otherwise adversely affecting a party is passed that the said party can be said to have any grievance. Of course, where the threat of a prejudicial action is wholly without jurisdiction, a person cannot be asked to wait for the injury to be caused to him before seeking the court's protection. If, however, the authority has the power in law to issue the so-cause notice, it would not be open to the person asked to so-cause to approach the court under Article 226 of the Constitution at the stage of the notice. The jurisdiction of the High Court under Article 226 of the Constitution should not be permitted to be invoked in order to challenge a so-cause notice unless accepting the facts in the so-cause notice to be correct, the so-cause notice is ex posse without jurisdiction. That is, the notice is ex posse a nullity or non-est in the eyes of law for absolute want of jurisdiction of the authority to even investigate into the facts, or totally without jurisdiction in the traditional sense of that expression. That is, even the commencement or initiation of the proceeding on the face of it and without anything more is totally unauthorized. In all other cases, it is only appropriate that the party shows cause before the authority concerned and takes up the objection regarding jurisdiction therein. Mere assertion by the petitioner that a notice is without jurisdiction would not suffice. It should prima facie be established to be so. Where factual adjudication is necessary, interference is ordinarily ruled out. Whether the so-cause notice is founded on any legal premise is a jurisdictional issue which can be urged by the recipient of the notice, and such issues can also be initially adjudicated by the authority issuing the very notice before the aggrieved party. can approach the court. A disciplinary authority has to keep a broad mind while issuing show cause notice. No doubt, at the stage of issuance of show cause notice, the delinquent employee should not be given an impression that he is going to be indicted or a finding of guilt has been predetermined. It appears that the issuance of show cause notice to the petitioner is based on the findings of FFC report, and thus it cannot be said to be arbitrary or malified in character. There is nothing on record that the authority lacks jurisdiction to issue the show cause notice. The governing body of the EMS Bhubaneswar accepted the FFC report as the preliminary inquiry report and approved to issue show cause notice to the petitioner by the competent authority. In the present case, though it has been alleged by the petitioner that the show cause notice is an exact facsimile of the FFC report, but it is not the case of the petitioner that an opportunity of hearing has been denied to him to counter the charges made against him. The FFC is an administrative mechanism which is usually constituted for ascertaining the facts, and it is on the basis of these facts that a show cause notice is issued. Therefore, if there are some similarities in the report of the FFC and the show cause notice, there is hardly any reason to doubt the impartiality of the disciplinary authority, and the FFC being genus and the issuance of show cause notice being the species, it is but normal to have some analogous character. Thus, we are of the humble view that there is no such illegality in the issuance of show cause notice to the petitioner, and the authority is quite justified in issuing such notice on the basis of the report of the FFC. In view of the foregoing discussions, we do not find any infirmity in the show cause notice dated 4/2/2021, so also any illegality in the impugned order dated 12/3/2021 passed by the Lenin Central Administrative Tribunal, Cuttack Bench, Cuttack under Annexure 10, and therefore it would not be appropriate and incumbent to disturb the statutory procedure and to superficially interfere at the fag end of the disciplinary proceeding. Accordingly, the writ petition being devoid of merit stands dismissed. It is made clear that we have not expressed any opinion as to whether the petitioner has been provided full opportunity in the entire disciplinary proceeding or on the merits of the disciplinary proceeding. And the findings of such proceeding shall obviously be based on the oral as well as documentary evidence adduced by the respective parties. With the dismissal of the writ petition, the interim orders passed earlier stand vacated.
Obliged, Your Honor. I agree.
Pardon, mention. Pattern mentioning my lord or division